Good day, everyone. I am Angel Grace Pontog from BSHM 3C, and now we're in Chapter 7 that talks about the law regulating transportation establishments. So, before we dive into the topic, here are the learning objectives. First, the identify the laws affecting the transportation sector. Next, to identify the rights of passenger of commercial transportation. And lastly, is to explain the relevance of these laws to the promotion of tourism in the country. So we all know that the Philippines has become one of the promising tourist destinations due to the extraordinary hospitality of the Filipinos and the diversity of tourist attractions in the country. However, one challenging aspect of promoting inbound tourism in the Philippines is the security and safety issue. On one hand, some of the best transportation and travel professionals are Filipinos, like seafarers, pilots, drivers, flight attendants, cruise ship cabin crew, aircraft mechanics, and many more. On the other hand, some of the worst recorded transportation disasters and accidents are in the Philippines. So the transportation sector is therefore greatly affected by this concern. So this chapter will deal with the different laws affecting the transportation sector as they are integral. So the first law is the law on common carriers. So the primary law that governs common carriers is the Civil Code of the Philippines as clearly implied from Article 1766, therefore which states that in all matters not regulated by this code, the rights and obligations of common carriers shall be governed by the Code of Commerce and special laws. So the law article 1732. So a common carrier is defined as one holding itself out to the public as engaged in the transportation of freight or passenger for hire. It is one who is in the business of transporting goods or persons for hire as a public utility. And a private carrier, in contrast, is not in the business of transporting public employment but hires out to deliver goods, not passengers in particular cases. So both the Civil Code and Code of Commerce give clear-cut divisions between contracts of carriage of cargo and contracts of carriage of passengers, because the rights and defenses in each kind of contracts are different from the other. So here is a sample application of the law for the private carrier of goods based on a charter agreement. So the MV Blassons 1 is a vessel which renders tramping service and as such does not transport cargo or shipment for the general public. Its services are available only to specific persons who enter into a special contract of charter party with its owner. So the term FIOST, which is used in the shipping business, is standard provision in the non-USI charter party, which stands for freight in and out, including stevedoring and trading, which means that the handling, loading, and unloading of cargoes are the responsibility of the charterer. And it is in the capacity that its owner, Vasson Shipping Incorporation, entered into a contract of affreightment or contract of voyage charter hire with National Steel Corporation. So, is MV Vessels 1 a common carrier or a private carrier? So, as for the legal opinion, MV Vessels 1 is classified as a private carrier, since it has been held that the true test of premier carrier is the carriage of passengers or goods provided it has space for all who opt to avail themselves of its transportation service for a fee. So a carrier which does not qualify under the above test is deemed a private carrier. So next is the nature of contract of carriage. So a contract to transport passengers is quite different in kind and degree from any contractual relation. And this is because of the relation which an air carrier sustains with the public. So it invites people to avail the comforts and advantages it offers. So the contract of carriage therefore generates a relation attended with the public duty. Neglect or malfeasance of the carrier's employees naturally could give ground for an action for damages. So next is the responsibility of common carriers. So the law article 1733, common carriers from the nature of their business and for reason of public policy are bound to observe extraordinary diligence in the vigilance over the goods and for the safety of the passengers transported by them according to all the circumstances of each case. Next is the Article 1755. So a common carrier is bound to carry the passengers safely as far as human care and foresight can provide. So using the utmost diligence of very cautious persons with due regard for the all circumstances. So next article is the Article 1756. So in case of death or injuries to passengers, common carriers are presumed to have at fault or to have acted negligently. So unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755. Next article is the 1757. So the responsibility of common carrier for the safety of passengers as required in Article 1733 and 1755 cannot be dispensed with or lessened or by stipulation, by the posting of notices, by statements on tickets or otherwise. So for more understanding, this is the discussion of the law. So as soon as the passenger puts his foot on the platform, the obligation of extraordinary diligence of the common carrier begins. So the relation of carrier and passenger does not cease at the moment the passenger alights from the carrier's vehicle at the place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or a reasonable opportunity to leave the carrier's premises. So, a certificate of public convenience is not a requirement in order for a common carrier to incur liability. So, such liability arises from the moment a person or firm acts as a common carrier without regard to whether or not such carrier has been granted a certificate of public convenience or has complied with the requirements of the applicable implementing regulation. So the term extraordinary diligence has been defined as the standard of care required of common carrier in bringing safely its passengers and goods from one place to another. So in a contract of carriage of passengers, it is the obligation of the common carrier to bring the passengers safely to the point of destination. So it discussed with the articles that if injured or death occurs, the presumption of negligence automatically arises, and the common carrier can be held liable if he fails to prove the extraordinary diligence for the duration of the carriage. So next is the liabilities of common carriers for the acts of employees and strangers. So the law Article 1759, common carriers are liable for the death or injuries to passengers through the negligence or willful acts of former employees, although such employees may have acted beyond the scope of their authority or in violation of the orders of the common carriers. So this liability of common carriers does not cease upon proof that they exercise the diligence of a good father of a family in the selection and supervision of their employees. So here's an example of the law. So for a bus company, due diligence in selection of employees is not satisfied by finding that the applicant possessed a professional driver's license. So that's not enough for the selection of employees. So the employer should also examine the applicant for his qualifications, experience, and record of service. So due diligence in supervisor on the other hand, requires the formulation of rules and regulations for the guidance of employees and issuance of proper instructions, as well as actual implementation and monitoring of consistent compliance with the rules. And next, for a shipping company. So the vessel must be considered seaworthy, adequately equipped for the voyage, and manned with a sufficient number of competent crews or employees. So next is the enforcement of liability of common carriers. So the liability of common carriers can be enforced on the following causes of action. So in case of death or injury caused to passengers, the victim may file a case of breach of contract of carriage or culpa contractual against the owner of the common carrier. And in case of death or injury caused to a stranger or pedestrian, the victim may file a criminal complaint against the driver of the common carrier for reckless imprudence resulting in homicide and damage to property. So the victim may also file a civil suit against the common carrier and its driver on the ground of culpa quilina or quasi delict. So next is the damages recoverable from common carriers. So in an action based on culpa contractual or culpa aquilina, so the damages that are recoverable are as follows. So the actual damages. So the actual damages consist in expenses for medicine, hospitalization, and many more. And for the unrealized profits are recoverable of deemed or decages which shall be fixed by determining the net yearly income of the injured or deceased passenger and multiplying the same by the number of years that he was expected to live or lead a gainful existence, as determined by mortality tables of life insurance companies of the Philippines. Next is the moral damages. So moral damages may be awarded when the mishap resulted in the death of a passenger. So 15, or when the heirs of the deceased suffered mental anguish. 1, or when the carrier was guilty of fraud or bad faith, even if death did not result. So the big amount of damages will be awarded in view of the importance of the person of the passenger. Next is the exemplary damages or corrective damages are awarded by way of example of correction of the public good or when the common carrier acted in wanton, reckless, and oppressive manner. So while the immediate beneficiaries of this standard or extraordinary diligence are of course the passenger and owner of cargo carried by a common carrier, they're not the only persons that the law seeks to benefit. So the Article 2231 of the Civil Code explicitly authorizes the imposition of exemplary damages in cases of quasi-delicts if the defendant acted with gross negligence. And award for that indemnity is in accordance with current rulings of the court. So award for the attorney's fee may be recovered when exemplary damages are awarded. So under Article 2008 of the Civil Code, attorney's fees may be recovered when exemplary damages are awarded. In the case of Metro Manila Transit Corporation versus Court of Appeals, it was held that an award of 50,000 as attorney's fees is reasonable. Next is the and in case moral damages cannot be awarded without proof of carrier's bad faith, ill will, or malice or wanton conduct, nominal damages may be allowed under the circumstances. So nominal damages may be awarded as provided under Article 2221 and 2222 of the Civil Code of the Philippines for the purpose of indemnifying the victim for any loss suffered by him. So the nominal damages are recoverable if no actual, substantial, or specific damages were shown to have resulted from the breach. So the amount of damages, such damages is addressed to the sound discretion of the court, taking into account the relevant circumstances. And next slide is the nature of airline, bus, and shipping tickets. So the best evidence of a contract of carriage is the passage ticket. So under jurisprudence, an airline pass or shipping ticket is a contract of adhesion, considering that all the provisions thereof are prepared and drafted only by the carrier. So the only participation left of the other party is to affix his signature thereto. In such situation, the Supreme Court ruled that the terms thereof must be interpreted against the party who drafted the same, in this case, the carrier. So, more discussion of this law is that such contracts of adhesion are not entirely prohibited and are in fact binding regardless. Thus, it was held that even if the passenger had not signed the plane ticket, he is nevertheless bound by the provisions thereof. So such provisions must so such prohibitions so such provisions has been held to be a part of the contract of carriage, valid and binding upon the passenger regardless of the latter's lack of knowledge or assent to the regulation. So the one who adheres to the contract is in reality free to reject it entirely. So if he adheres, he gives his consent even if the conditions are printed in small letters that does not make the ticket or bill invalid. However, however, the courts will exercise greater vigilance when dealing with contracts of adhesion. So, in that, the said contracts must be carefully scrutinized in order to protect the weaker party from deceptive schemes contained in ready-made stipulations. So, this is an recognition of Article 24 of the Civil Code, which mandates that in all contractual property or other relations, when one of the parties is at a disadvantage of account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for this protection. Next is the regulation of the transportation business. So the planning, programming, regulating, and administrative entity of executive branch of the Department of Transportation and Communication or DOTC, the primary policy government in the promotion, development, and regulation of dependable and coordinated networks of transportation and communication system, as well as in the fast, safe, efficient, and as reliable dostal transportation, and communication services. So it has the power, authority, and technical expertise to determine whether or not a specific transportation or communications project is necessary, viable, and beneficial to the people. Next is the regulation of air transportation business. Legislative Act Number 3909, passed by the Philippine Legislature of November 20, 1931, created an office under the Department of Commerce and Communication to handle aviation matters, particularly the enforcement of rules and regulations governing commercial aviation as well as private flying. So it was amended by Act 3996 to include licensing of airmen and aircraft, inspection of aircraft concerning air traffic rules, schedules and rates, and enforcement of aviation laws. Then the registration of aircraft. So the only aircraft owned by or leased to a citizen or citizens of the Philippines and which are not registered under the laws of any foreign country may be eligible for registration. So the certificate of registration is conclusively evidence of ownership, except in a proceeding where such ownership is an issue or when the aircraft is only under lease. So here is the application of the law. So the Filipinas Airline Company Flight 888 crashed in the mountains of Bukidnon, killing all the passengers over the aircraft. So the airline company wants to know what really happened. So who has the jurisdiction to investigate the accident? So for the legal opinion, so the Air Transportation Office or the OTA has the jurisdiction to investigate the aircraft accident and must submit its investigation reports to the Civil Aeronautics Board. To the Civil Aeronautics Board. And next is the regulation of the LTO. So the LTO is the proper agency which controls the registration and operation of motor vehicles and the licensing of owners, dealers, conductors, drivers, and similar matters. Under the Clean Air Act of 199, vehicles must pass the emission testing requirements to be administered by the Department of Transportation and Communications as a prerequisite for registration or the rules and regulation of the marina. That's why every driver has to follow the requirements when driving any vehicles, just like a smoke test every year. Are the standard requirements for tourist land transport vehicles. First, so must pass the roadworthiness inspection by the Department of Tourism and the maximum age limits for buses or coasters 10 years from manufacturer, and for the tourist cars 5 years from manufacturer, and for the luxury cars 10 years from manufacturer, minimum of 2090cc engine not locally assembled, and also must have left-hand drive, air conditioning, and a fire extinguisher. So additional requirements for buses and coasters, they must have a public address system and also first aid kit and emergency medicine. And comfortable seating, legroom, and storage space. And operators must provide a garage, repair shop, and parking space. They also must have a clearance from the PNP or the Philippine National Police is required for registration, ownership, transfer. And this is the standard requirements for the tourist air transport. They must have life-saving devices and communication equipment as per Air Transportation Office regulations. So in complying all these requirements, you need to show all documents required to support application for accreditation to operate as tourist transport operator. So the next law is the seatbelt law. So here are the requirements for this law. So the drivers and front seat passengers in public vehicles must wear seat belts while the vehicle is running. And drivers must inform and require passengers to wear seat belts before proceeding. And also the passenger who refuses cannot continue their trip. And for the child safety, children 6 years old and below are not allowed to sit in the front seat. And for the vehicle importation, importing vehicles without operational seatbelts is prohibited. And for the registration compliance, new vehicles must comply with seatbelt regulations for registration. And non-compliance results in denial of registration or renewal by the LTO. For the non-compliance results in denial of registration or renewal by the LTO. Next, the law on transportation of animals. So the law by virtue of Republic Act 848565, also known as the Animal Welfare Act of 1998, it shall be the duty of any operator of any land, air, or water public utility transporting pets, wildlife, and all other animals to provide in all cases adequate clean and sanitary facilities. In order to assure safety of passenger and crew members of aircraft or vessels, it is necessary to obtain a shipping permit from the Bureau of Quarantine before an animal may be allowed to be transported on the board. So the Bureau of Quarantine has required documents as certified by a licensed veterinary doctor or veterinary clinic or hospital to be presented before a shipping permit will be issued, just like a certificate of rabies just like a certificate of rabies vaccination. Next is the Public Service Law. So the public service includes every person who may own, operate, or manage or control in the Philippines for hire or compensation with general or limited clientele, whether permanent, occasional, or accidental, and done for general business purposes. So any common carrier, railroad, or street railway, train, traction railway, subway, motor vehicle, and many more. So unless otherwise exempt, no public service shall operate without having issued a certificate of public convenience or certificate of public convenience and necessities. So these certificates are important for you or as a public carrier should have this presently to operate. As mandated by law, no public service shall operate without having been issued a certificate of public convenience, which is considered a privilege and not a property right. So, a certificate of public convenience is an authorization granted by the proper government agency for the operation of public service for which a franchise is required by law for public use as required by law. So here are the rules on registration of motor vehicles. So for the vehicle registration, all motor vehicles must be registered. Next is the restriction as to speed. So showing you the table with its corresponding maximum allowable speed in different speed. Next rules are the parking prohibition. So no driver shall park a vehicle or permit it to stand whether attended or unattended upon a highway in any of the following places. First is the within an intersection, on a crosswalk, within 6 meters of the intersection of curb lines, within 4 meters of the driveway entrance and a fire station, within 4 meters of fire hydrant, in front of a private driveway, on the in front of a private driveway, and then on the roadway side of any vehicle stopped or parked at the curb or edge of the highway, at any place where official signs have been erected prohibiting parking, or a sign that indicates no parking symbol. Next is the driving and substance intake drug. So no person shall drive a motor vehicle while under the influence of liquor or narcotic drugs. Next is the obstruction of traffic. So no person shall drive his motor vehicle in such a manner as to obstruct or impede the passage of any vehicle, nor while discharging or taking on passengers or loading or unloading freight obstruct the free passage of other vehicles on the highways. Next is the Kalesa operation and its Kalesa operation and accreditation requirements. The driver and permit requirements. They must have a mayor's permit or municipal license and must pass a Kalesa driver seminar by the department or an unauthorized organization, and it also requires a police or barangay clearance and a certificate of good health for both driver and the horse. The other documents as are required by the department. Next is the Kalesa physical requirements. Made of high So they must have made of high quality materials with neat paint and prescribed markings, and also equipped with a non-skid stepping board and comfortable seats, and also must be clean and well maintained. And for the horse requirements, the horse must be in a good physical condition. And for the operational standards, they must have a road worthiness fit for public road use. And for the seating capacity, maximum of 2 passengers. And also they must have a first aid kit must be available in every kalesa. And the horse waste management. So the kalesa must have a waste receptacle at the rear side of the kalesa. And for the kalesa driver conduct must be trained, well groomed, courteous, and wear the prescribed uniform and DOT ID. And they should ensure safe, comfortable, and convenient service for the passengers. And also, kalasa driver must take care of their horses. And for the routes and operations, they must operate in tourist zones, belt areas without disrupting the traffic, and also restricted to the city or municipality that issued the permit. And for the fare regulation, they must follow the charge. They must charge only the approved fares of the community. And so, and that's all for the topic 7, and hope you learned something. Thank you.